Ladies and gentlemen, shall we open our panel here? I'm sorry for having you to wait a little bit. What I would like to say is, in terms of introduction, perhaps some of you plan to attend this panel beforehand and probably look through the list of participants, and now you would be surprised to have a different composition of the panel, which means that this industry, this trade is very dynamic and changes right in front of our eyes. And I thank those people who decided and agreed to come right today in the morning to attend this panel. So I'm happy to see that we have fast reaction from the authorities. The subject of our panel would be the protection of personal data and the regulation of this issue, not only in the Russian Federation, but worldwide. I think that it is not really an ambitious task, but rather a plan to discuss the news that we might expect as society in light of the developing technologies. And we noticed that our personal data being stored in clouds, in personal gadgets, and hence the world has even some opposing trends. For example, the creation of anonymous networks. The most recent startups in the Silicon Valley were about creating networks, social media that would be totally anonymous to prevent publicity and to create private space. There is another trend, the over-regulation of this area, and the governments are trying to protect the individuals from possible risks in this area. So I would like to offer to your attention a constructive dialogue and discussion as to how we view this whole topic, how this is viewed by regulators, not only in Russia, but also in other countries. And where suitable, we would be able to discuss some more specific matters, some novelties in law. You know that in the Russian Federation we have adopted a law which is an old one, actually, but with recent amendments, and hence, in light of this law, there is some public debate on this subject. This is the plan for our today's panel. Let me introduce the first speaker in our panel, Mikhail Yakushev, who is Vice President for Eastern Europe and Central Asia, the Internet Corporation for Assigned Names and Numbers, ICANN. Mikhail, the floor is yours. Thank you, Alevtina, and good morning, dear colleagues. I'm happy to present here on a subject that I personally like very much, and I can explain why. And also, the corporation that I represent here today actually is about the unique identifiers and universal metadata in the Internet on a global level, domain names and IP addresses. But here I would like not really to represent my corporation, but rather as a lawyer, as an expert in this field, to give you some background, but also to share with you a vision as to how the regulation of personal data protection might develop. The personal data protection institution or phenomenon is a young one, less than 10 years old, and to integrate this into Russian law, the Russian Federation signed a European Union or Council of Europe Convention on the protection of personal data in automated processing. the ratification of this convention was procrastinated, and in 2005, at the level of Dmitry Medvedev, chairman of the Russian government, instructed us to prepare a whole package of documents to be able to ratify that convention. That work was done within the Ministry for Telecommunications, and I back then was working in that ministry, and I was secretary of an interdepartmental working group to prepare the package of laws, of draft laws, and we managed in a very concise time to prepare such documents and agree that with all the core ministries, the law on the ratification of this personal data convention on information technologies, and a number of other laws and regulations. The participants in that process are present in this forum. We saw Vladimir Pligin, who is heading the appropriate committee in the State Duma of the Russian Federation. We have people who participated in this effort here in this audience. We are not ashamed of what we have done. What we did was approved on the 16th September of 2005 by the cabinet, by the government, and the package of laws about personal data protection was introduced into the State Duma. You can read that on the website and then compare that to what actually was adopted by the State Duma, compare with the amendments that were done later. When the personal data law was being written, the main idea was to protect the interests of our citizens, whom we call the subjects of personal data protection, their rights as individual, the right to privacy, and this was done in line with the best practices of the European countries. We had some field trips to the UK, the Netherlands, Germany, to meet the experts in this area, where we discussed those laws and made some amendments. The main idea was that the regulation in this country and in Europe, as part of within the framework of the convention, would be uniform and would not contradict each other. We managed to resolve this, but what happened after the law was introduced in the State Duma in the 10 years past, we know what was happening, and it would be good to analyze all this. Now, skipping and fast-forwarding to the present, I probably would dwell upon what would be happening looking forward, and I always provide the following analogy. When people were making an A-bomb, the physicists who were working in this field were asked, how could you do things that may kill a lot of people? And Andrei Kaferny, and one of the leaders of the nuclear project in the US, he said that to a physicist it is quite interesting to work in nuclear physics. That's why we are doing that. So personal data protection is a good legal theory, which is an interesting project to take. But to adopt laws, to adopt regulation in this dynamic field, we need to also to have a good theoretical background and understanding of what would be personal data and the internet, so that legislation would be in line with the societal relationships that we are planning to regulate and manage. So we now have this institution of personal data protection and the subject of personal data protection, and this is not going to go away in 5 years. We lived until 2005 without personal data protection as part of our legislation. Now we have such an institution, such a body of law, and we will be living with that. So the question now is, what will be the demand for this, and what will be the frequency of application of the appropriate legal norms? Until 2005, we never had this problem, and the challenge was there, but it was not written in law. There were few legal cases and judgments, and we wouldn't have noticed that if we had proper regulation, and we would have been able to regulate this on the basis of law. But in everyday life, for many years, and even today, personal data is a phenomenon that we don't really need. In transacting, we are not really passing on our personal data, so we don't have any legal relations emerging from that. But the situation is changing. And the most important thing that we may expect in the coming years would be the new personal data format to appear. So the question is whether they are new, actually. Various identifiers in the internet, could they be called personal data, or take social network accounts? There are some debates about whether such accounts are verified or not verified, or even take biometric data and face images, which are being frequently used even without our knowledge. There's another challenge. In addition to the new formats of personal data, there are new ways of using personal data. I can give you a simple example which can be quite characteristic. There was information that in Moscow we are planning to monetize such a sector as access to web cameras, to CCTV. We have thousands of those TV cameras in buildings, in apartment houses and in the underground that can be used to monitor crime. So there was a suggestion that anyone can pay for an access to such a CCTV and have it, the images downloaded to his or her computer. So there could be some ridiculous things, like a husband would say that I'm going to the library, but then the wife would see that the husband is going to a beer pub, and then using the web camera can watch what the husband would be doing there. So, of course, the question is whether we violate the rights of the person being monitored. In the UK, the traditions of such a CCTV monitoring has a much longer history, and some of the issues have been already resolved, so we need probably to transplant the positive experience of other countries here locally. Another challenge is the possible number of crimes and legal violations that might be even more frequent because of the lack of regulation of personal data. We're talking about identity theft, which can be done for political purposes. We know how often that was done during election campaigns. Also, personal data would be an important thing to insurance companies, especially when you're talking about establishing the health state of a person for medical insurance or for other insurance. So without any control over the dissemination of such personal data, there could be a violation of privacy. So we need to think about the adequacy of such personal data protection and the prosecution of those guilty in breaking such and violating such laws. In addition to new formats and new ways of using the personal data, there are also new technological possibilities of transmitting personal data and presenting such personal data. And here we see a number of unresolved theoretical issues. In the last 5 years, we have seen the emergence and spread of clouds, both public and private clouds. And this is something that we can expect to grow in the next few years. This is being actively used in the US and in Europe, and sooner or later this is going to be used in Russia. Just by how much the data that we are placing into clouds are protected. this is not a simple question or a trivial question. When we disseminate data about ourselves in the internet, in clouds, we're talking about public domain for such data. When we are using some, even a simple set of identifiers, we can really think that such data would be used by others, because again, this would be broadly accessible, even if you're talking about social media, which require passwords, but we cannot control how this information is going to be used by third parties later. So social media penetration and the broad use of social media networks in everyday lives, like placing photos of who you danced with or where you dined, may cause some serious changes in the regulation of personal data. And perhaps we can also speak about the integrity of private life. And last thing, if you're talking about technologies, then how this may be developing in future. I think that those who had their education in the Soviet high schools and colleges would remember probably about dialectics and the dialectic spiral. It seems like they're entering the new spin in this spiral, and if some time ago, say 100, 200 years ago, we never had any personal identification document which would identify a person, but then we had the appearance of paper documents. Now we have electronic documents, so we need to think about how to protect data in those electronic documents. And such electronic documents are being widely used not only in offline but also online. With the advance of the payment systems and the involvement of such electronic data in trade and in the provision of governmental services, the question is how to make it comfortable for a person to use such possibilities and how to protect and secure such data. So if we are talking about this dialectical spiral, then perhaps we come to a point when data about us would be stored in electronic devices that we carry, and that would basically identify us without the need to present your photo. And we're talking about mobile phones, watches, or some electronic cards. This is being developed by many companies like PayPal, and I know that interfacing personal data with a mobile phone being used by that person is something that is being developed, so that the identity can be proven and the bank account details can be confirmed.
I think it would be ideal if we would arrive at a situation where the identification and transfer of personal data would not be required at all. This would happen automatically when certain legal relations emerged, and the transfer of data would be just a technological question, so that there are no leaks of personal data, and so that we didn't have to show our password when we crossed the border or boarded plane. So everything would be automatic, as it was 100 or 200 years ago, but at a new historical level. Thank you for your attention. Thank you very much, Mikhail, for your ability to compact so much data in one unit of time. Our time is limited. Of course, we would like to hear more from you, because it's very interesting. You have a very interesting vision of what lies in store for us in the future. But our task now, well, understanding that we are faced with this challenge, including the legal challenge, and we are going to face it in the future with all the difficulties and opportunities that new technologies bring to us. I think we should now start discussing how we lawyers and business people see the system of regulating the protection of data. That would be the most effective in this context. And I would like to give the floor now to representatives of to our European colleagues who work in this field, who specialize in this field. And probably we will start with the representative of Germany. This is Miss Commissioner. and member of the Commission for Data Protection of Hessen, Professor, Dr. Michael Ronelentich.
Zunächst mal guten Morgen, vielen Dank, dass ich da sein darf. Ich hoffe, ich bin akustisch einigermaßen zu verstehen. Ich muss eine Vorbemerkung machen. Die politischen Beziehungen zwischen
Okay, I would like to say the following. Political relations between Russia and the European Union are somehow disrupted. They are not in balance, and we will try to rectify this, and I think we have quite a good prospects for economic relations. They will be good if we understand each other, also in the field of data protection. Both parties should understand, and they do understand, what data protection means. At the European level, we understand that we consider that data protection should be formulated slightly differently than it is done here in Russia. I think that in Europe we should agree on what do we need there, and we have taken the German model. The Germans didn't want this, and we are not trying to be complacent about that, but this is a fact that the data protection standard developed in Germany was adopted at the European level. We would like to see the European system to be more modified, unified. So there are many debates going on, and I think that appropriate laws and regulatory acts are going to be adopted in August. We hope that we should come to an appropriate solution. What do we mean by data protection? Nobody knows what it really is. How can you protect information? How can you protect information? What does it mean? How to catch it by its tail? What is it? Personal data, identifying a person, business information? Well, this has been discussed for a long time. Personal data is individual information, but it is also important to understand economic parameters. It is important to understand the parameters of government entities' operation, new laws and regulatory acts, instructions or whatever on the protection of personal data pertain only to personal data. They are not. It has nothing to do with business information or information about the government. We are talking only personal data. And here it is not very interesting that, well, that you are sitting in a pub while you should be in the office. This is not the most important thing. German regulators, European regulators, and there is the so-called big data, and we haven't resolved this problem yet. Well, so much information is collected on a person that it cannot be processed, and this information includes more than a person knows about him or himself or herself. So some information just lies somewhere in a database, and then the identity of a person is infringed upon. Here we should regulate the situation. This is a problem for Germany, for Europe at large, and I think it will be a problem for Russia. And now we must seek a solution to this problem. We should overcome a situation where the government has a huge package about each and every human being. So, and this information should not be kept by Google or social media without the prior consent and knowledge of the individual in question. This is very important if you are negotiating a sale contract and you've said something to your counterpart, and this information all of a sudden becomes known to someone else, even including your relatives, while you don't wish that. This is a problem that must be resolved at the international level, at the global level. In the UK, they are trying to resolve that in their own way because they have a different approach to the protection of personal data than in Germany. Economic parameters are important for us. Business information is important for us. Transformation of this information from the national level to a more global level. What is the Russian understanding of the protection of such information? We need to understand that in Europe as well. Access to information and regulation of the flow of information which may be transferred from the national to a global level. All this creates certain problems if standards have not been agreed upon. If standards of the European Union are not in line with the standards of some other country, for example, Americans, who take a lot of care in terms of protection, collection of information, protection of information, still they come across problem and there are lots of issues of understanding or misunderstanding rather of the position of your counterpart. Snowden, who found his second house in Russia, and he introduced a huge amount of turbulence in the topic of data protection. We need to sort that out as well. Well, are certain national standards, do they apply to Snowden? Maybe he talks too much or can say too much. Does he have a right to share the information that he has at his disposal? And, well, there are lots of issues with the factual use or misuse of the convention that we agreed. Those conventions are good, but their application, well, faces huge difficulties. Information is collected with for one purpose, and then it is used for a totally different purpose. The information is kept somewhere, and then all of a sudden this information becomes alive again, and it's used as an evidence proving something else, and the person can be held responsible using the information that was collected and was received in some database 100 years ago about him. The accumulation of this data, the storage of this information, profiling of its use becomes a greater and greater problem, also in the economic sense. In Germany, a huge amount of information is kept at the European level. A lot of data is collected. There is a whole classification of different type of data that is collected. There is information pertaining to Russia, and in Russia, of course, you also have data on about your citizens. It is also going to be used in different ways and understood in different ways.
Thank you very much, Professor, for a very concise speech. And very informative one. It was really interesting to see that the system we expected to be the most regulated is still putting questions in front of themselves. What is data? Shall we regulate? And while we thought you have answers to all questions already,
Okay, we are switching over to the presentation by Mrs. Jan Rudgard, who is a partner with Hogan Lovens in the London office. She's been dealing with this topic for a long time, and she participated quite actively in the development of various European laws and regulations on this topic. It would be interesting to hear from her opinion about the regulation in this field.
Hello everyone, good morning, and I have to say it's a real privilege to be here today talking to you all, and a real treat for me to be in St. Petersburg. So first of all, I think just a little bit about my background. I worked for the UK Information Commissioner for several years, back when the UK law was being brought into force. And so I've seen the current law develop over the years. And now, of course, in Europe, what we're facing is a revision of that law. So it just goes to show how long I've been in the field of data protection and privacy. And so what we have is a law in Europe, in the EU, I should say, which is now past its sell-by date. It's not fit for purpose, in that the technology has developed so much over the last 20 years, and businesses and the regulators are struggling to keep up. And so what we have in Europe is maybe not so dissimilar as the position that you have in Russia, is that we are facing new laws. And so in an effort to streamline the law that's in place at the moment, which is effectively derived from an EU directive, which then is transposed into the national law of each member state, the result being that we have very different interpretations from a single EU directive, depending upon the law and the philosophy sometimes in the member states in question. And what we are looking to now is one single regulation, which is going to have direct effect into each member state. So when we, in the UK, for example, have been used to a particular interpretation of the laws which have been enacted through our Parliament, what we are facing now is a law which is being set at a centralised level. And so the challenges that we have maybe are not so dissimilar to you here, with a relatively new set of laws, and also changes on the horizon as well in the near future with the data localization. So in some ways, we're very much in a similar position. So just looking back a little bit, what the European law has sought to do is to try and find a balance between the protection of the individual against the need for free trade and business interests. And that's the challenge that has been faced all over the years since the initial law came into force. And whereas when the directive was enacted into the individual member states, we were looking at a situation where the fear was of globalization. How can we protect the data from Europe that is now traveling around the world? How can we try and keep a standard which is equal to the level of protection that we have in Europe? So in a sense, there was a level of localization going on way back. So maybe this is not new. And we're now looking at a trend in Europe as well, where against this idea of globalization, because we're seeing in a lot of the member states a real desire to keep data in Europe. So this is a trend that we're seeing that was actually even starting before the Snowden revelations. So, for example, in France, in particular, there was a business need was seen to try and keep data in the cloud in Europe, in France. And so it was being driven by commercial interests, maybe rather than privacy interests. And that then has developed over the years because, of course, then we've had all the issues with the Snowden revelations and so forth. And so what we've got, also, we've got certain businesses which are now marketing in Europe to say, come to us, put your data with us, because we will keep your data within Europe. So again, there are some themes here that we're talking about localization now rather than globalization. When just looking briefly at the law that we have in Europe, maybe it's might be helpful just to explain how it's framed at the moment in terms of transfers of data from Europe. if you are established in the EU, you are prohibited from transferring data outside the EU unless you have in place what is known as an adequate level of protection. And so the challenge that I have working with businesses all the time is those businesses that are operating on a global scale is how to comply with the law in Europe, because inevitably they will have clients, customers, employees elsewhere in the world. So that might be intra-group arrangements and also working with third parties such as customers and vendors. And so what we have is a situation where we have a certain set of tools at our disposal to try and offer to businesses to find a solution to their problems. So we look, for example, at safe harbor. If you're working in the United States and you have business, either part of your business is in the United States or you're using vendors in the United States, there is the option to sign up to the safe harbor framework, and many of you will be familiar with safe harbor. Safe harbor is a system whereby you commit to complying with a certain set of principles and policies to essentially ring-fence the data within a safe haven. Safe harbor's always been a little bit controversial in that one of the flaws was perceived to be the fact that businesses might use safe harbor as a basis then to transfer data on to other countries or organizations, and so therefore this onward transfer principle has always been perceived to be a weakness. So all this has been brought into sharp relief over the Snowden revelations, and some of the data protection authorities have been very vociferous in suggesting that maybe safe harbor needs to be radically changed if it is to continue, and there are very active movements being taken place by the European Commission in consultation with the United States to try and review and maybe remodel the safe harbor framework. So that's the first thing that we are contending with. So businesses come to us and they will say, oh, is it okay to use safe harbor? What should we do? Is safe harbor going to continue? So there are challenges there. We've also got a legal case that's going to be heard in the summer. It's based in Ireland. There's been challenges over whether we can actually accept safe harbor as it is. It's being brought against in relation to Facebook transfers. And so maybe even by the summer, we will have a legal ruling on the future of safe harbor. So the other options, model contract clauses. Again, some of you may be using model contracts for your transfers from Europe. They're quite restrictive in that if you depart from the terms of those clauses at all, you have to go to see your local regulator and you have to find out whether or not they will approve them. So again, you've got the challenge there of some of these restrictions for businesses working in a global environment. Movements over the last sort of 8 to 10 years have been in the form of global compliance policies, and maybe this is actually the way that we're moving in Europe, in the EU, is that if you are operating on a global scale and you have a global set of standards which meet a certain level as prescribed in the law, then if you get approval for these from your local regulator, then you can transfer certainly intra-group on the basis of these standards. And these are called binding corporate rules. And binding corporate rules is something which was quite a flexible, innovative proposal brought forward by the EU in 2007. And it's slowly gaining interest. And maybe this is something which I suggest to you as a possible way forward in terms of managing some of the global compliance issues that you're going to be facing. So although BCR, Binding Corporate Rules, is very much an EU concept, the APEC countries are also working with the EU to try and broaden this as a tool. And so, as it's also recognised in the new regulation, then it's something which I think will become more standard procedure in the future. So the question, I guess, that you would have for me is, so how is that going to work within Russia, where you have a consent-based approach to transfers of personal data, if I'm right? I would say that maybe it is a tool that you could also be using, provided that you comply with your national law and you get the appropriate consents and whatever else is provided, and you also comply obviously with any localization requirements that are coming online. Then that may be also a tool that you can use to assist not only with any of your European requirements if you have establishments across Europe, but also if you are looking to comply with your own law that's coming online, because essentially a lot of these laws, whether they're here or whether they're in the EU or in other parts of the world, there are basic principles which are similar wherever you are. And it's not too difficult to find a common theme throughout. So that's a proposal, a thought that I'm going to just leave you with from that point of view. And then I think the other, sort of a couple of just sort of other points is that when we're talking about data being transferred anywhere in the world, wherever it's kept, the key point is the security of the data. Wherever it is, if it's not secure, whatever laws you have in place, it's not really going to make much difference. And so security is key. And in the EU, we're seeing that our new regulation, which is we're expecting that to be coming in a final form within the next year and operative within 2 years. We're going to have mandatory data breach notification, very much as we have in the United States. There's going to be greater regulatory involvement in that if you have all these reporting requirements, you may be brought within a more visibility of your regulator, and so there again, the standards are getting higher and the challenges for businesses are increasing. The other point that I want to make is this idea of accountability, which is being brought in through the new regulation. So accountability is a context which is familiar in some EU member states and not others. It's certainly not something we are familiar with under UK law. And accountability is essentially part of the law saying that not only do you have to comply with the law, but you have to demonstrate compliance. And that is new for us in the UK. It's maybe not new across the EU. But again, what it means is that the essential part of your privacy program is going to be being able to demonstrate compliance with the law. And so you have to show that you've got policies and procedures, show that you have a data breach protocol in place so that if something goes wrong, there's a procedure. Your staff are well trained, your data subjects know exactly how you're going to use their data. And so again, it's all about demonstrating compliance as well as being able to do it in practice. So I don't know whether that's a helpful summary of what's
that's
going on. That's a
very helpful summary, and one of the, you're very also helpful in understanding the tendencies in Europe, and by looking through the tendencies that you just named, it is obvious that we, in one or another way, we are all healing toward the same direction.
Yeah.
The matter is methodology we use, and basically result we want to reach, and that's all we have to agree. But the thoughts how we have to do this, we have more or less alike. So now details matters.
Yeah.
Спасибо большое. Мы переходим к следующему докладчику. У нас
Well, thank you very much, and we're coming to the next speaker, and we have a request from the Italian delegation to speak on the subject, Ms. Allegra Mellarini, and I would appreciate you if you would pronounce your name correctly. Ms. Mellarini is a public prosecutor, and she's working with the General Secretariat of the Ministry of Justice of Italy.
если вам будет удобно,
If you like, you may take a seat on the panel and discuss the experience of Italy in this matter.
я так понимаю, перевод, да, будет с итальянского языка, да? Ну,
I understand this is going to be a consecutive interpretation from Italian into Russian. Please.
Buongiorno, ringraziamo per questo invito che ci è molto gradito e siamo contenti di condividere con voi la nostra esperienza in questa materia così nuova e così sensibile.
Good morning. I would like to welcome all of you here and thank you for the invitation to attend this wonderful panel. We also wanted to take part in the discussion of this novel topic for all of us.
Il diritto alla riservatezza, tradizionalmente inteso come diritto ad essere lasciati soli a tutelare la propria vita privata da ingerenze non autorizzate, si è legato col tempo a esigenze di tutela della dignità della persona e è stato riconosciuto e sancito dalla Carta dei diritti fondamentali.
The right to protect personal data is traditionally perceived as the right to be left alone and to protect your own privacy without unsanctioned interference. But with time, this was intertwined with the protection of human dignity, and it was recognized by the European Charter for the Basic Human Rights.
Sono trascorsi 11 anni da quando in Italia è entrato in vigore il codice della privacy.
It has been 11 years now since in Italy we adopted the Privacy Code.
E molto è cambiato nella materia. All'epoca Internet non aveva il carattere indispensabile che ha ora.
And since then, we have seen many changes in the protection of personal data. In the Internet era, this was not something that we could have called interference, but this, when there was not Internet, it was not really something that we would call interference, but today it is a very pertinent issue.
È rimasta immutata perché così lungimirante ed utile è riuscita a far fronte a una realtà che è naturalmente in costante mutamento.
But we can proudly say now that the provisions that we have in our privacy code have remained intact for the most part, and this demonstrates our farsightedness and flexibility, and the fact that we could have adapted to the constantly changing world.
Della privacy significa restare al passo con l'evoluzione tecnologica e ricondurla nella sua fluidità all'interno della cornice fissa delle norme. Ma serve un equilibrio dinamico.
Дисциплинировать те формы, которые принимает контроль над персональными данными,
to regulate the forms of control of personal data means that we need to be on par with the technological advancements, and we also need to be quite flexible in terms of our legislative approaches.
Bisogna far convivere elementi che confliggono, la tecnologia e la socialità, la libertà e la sicurezza, la trasparenza del pubblico e l'opacità del privato, l'iniziativa economica e l'autonomia individuale, e bisogna usare quindi con sapienza, rigore e duttilità.
Мы должны уметь сочетать,
We need to be able to dynamically combine and balance frequently conflicting
моменты, такие как
aspects such as freedom and security, such as transparency of public data and intransparency of private data. And all these aspects should be used on the one hand with flexibility and on the other hand with rigidity.
Ed è così che il codice italiano è stato costruito, con una lettura costituzionalmente orientata del nuovo diritto, ricostruito attraverso il principio del rispetto della dignità umana, del diritto alla propria identità personale e del diritto al libero sviluppo della personalità.
And the Italian Code of Personal Data Protection of Privacy was established on the principles of the Constitution in the spirit of the new laws and with a view to protect the dignity and personal data and the free development of each individual.
Però il risultato, questa capacità di adattamento che il nostro codice ha dimostrato, è stato ottenuto attraverso anche una felice combinazione di previsioni normative e strumenti più agili, come i regolamenti, i codici deontologici, il potere riconosciuto all'autorità garante di emettere autorizzazioni e linee guida che avessero funzione integratrice.
I should note here that the ability to adapt in this legal field was possible thanks to a favorable mix of regulatory norms and other instruments like the codes and regulations that recognize that the regulator is able to issue various guidelines and instructions that cover all the aspects of this subject.
Ad esempio, la definizione di parametri integrativi delle norme si è fatto ricorso a codici deontologici affidati nella loro redazione alle categorie che sarebbero state i destinatari di quelle norme, ad esempio i giornalisti, le banche, perché erano i soggetti più sensibili e più consapevoli sulle ricadute applicative delle norme stesse.
Так, например, при определении
Thus, for instance, in establishing the fundamental parameters and standards of law, in compiling those codes and laws, we actually asked, say, journalists or bankers to come up with the proposals on particular matters of personal data protection, that is, to people who actually would be influenced by any decisions made in this area.
Precisazioni nelle norme, come ad esempio la videosorveglianza, la biometria, i data breaches nei rapporti di lavoro, si è fatto ricorso alle linee guida che potevano dettate dall'autorità garante.
In other areas where there was a need in more accuracy, such as CCTV or biometric data or identity thefts, we successfully used the guidelines of the regulator.
E poi è stato attribuito sempre all'autorità garante il potere e dovere di rendere dei pareri sugli atti normativi delle altre istituzioni che decidono su temi che incidono sulla riservatezza dei cittadini.
Also, the authority which serves the role of the regulator was able to come up with a minority opinion on the functions of the bodies who can make decisions and to come up with the proposals that may have some impact on the level of protection of personal data.
Nella legislazione europea che il diritto alla protezione dei dati ha la sua genesi e anche la sua proiezione più significativa. Per questo l'Italia durante il semestre di presidenza dell'Unione ha profuso il massimo impegno per consentire a questo regolamento di arrivare ad approdare a fornire quella legislazione uniforme in tutta Europa.
Но именно в общеевропейском законодательстве
But in the European Union law, the right to personal data protection also was the source for such data protection. And during the Italian presidency in the European Union, a lot of effort was made to put those principles into practice.
Non è soltanto quello accademico, ma è quello di fornire un effettivo rilancio e funzionamento per l'economia moderna.
Все это было сделано не столько с академической точки
All
зрения,
this
сколько с практической, чтобы
was not a purely academic effort, but rather a practical effort to promote economic development as well.
My apology, we have time.
Sì. Quindi mi riallaccio a quello che diceva le rappresentanze del United Kingdom sulla necessità di costruire una privacy dall'inizio negli stessi strumenti che ne sono l'accesso alla rete che sarà oggetto degli attacchi e dei rischi per i diritti personali dei cittadini, alla protezione dei dati dei cittadini.
Well, to conclude my presentation, let me go back to the presentation, to the words of my colleague from the UK, who talked about the need to construct a personal data protection system with the tools that would be providing for the risks and dangers that might cause data theft in the internet.
E quindi, vista l'impossibilità di dilungarci, rinvio eventualmente alla relazione che invierò all'organizzazione.
And since, because of the time limit, I have to finish earlier than unplanned, I will provide my full text of the presentation to the organizers so that you would really read the logical end of my speech.
Thank you very much. Now we are transitioning from the European vision of this area to a discussion on how the regulation of personal data is seen and what has been done in this area in the Russian Federation to date. I would like to give the floor now to Vadim Dengin, who is a member of parliament and first deputy chairman of the Parliamentary Committee for Information Policy, Information Technology and Communications. Vadim, you have the floor. Good morning, dear friends. It was great that Mikhail made a very detailed presentation. He described the topic in a very thorough way. I am an MP and I need to be governed by what simple citizens need. Those who vote for any party or whatever. And for ordinary people, the notion of personal data is quite different from what we understand under personal data. What do our simple people in a village or wherever think about what personal data is, even in Moscow, wherever? Telephone, some card, keeping personal data on servers and data centers, all it's true for Europe, Russia, the United States. We are trying to kind of complicate things for them, but when we talk about adopting a law on protection of data, I'm one of the co-authors of this piece of legislation, and I am saying that, first of all, as the government, we need to ensure safety and security foremost. For the government, security is priority number one. Business is priority number two. We are not interested how businesses are going to cope with this law. iClouds recently have shown their lack of protection, and simple disks that you can carry with you, they do not give you any protection for photos or other things that you keep there. Therefore, people have started to keep things in a cloud, and it is very easy to break them into those clouds. Stars of the showbiz probably do this themselves to leak information in order to get some publicity, but ordinary people like ourselves, I don't want someone to steal my personal medical data or other data, brought them over to the internet, and then our foreign colleagues would be saying that we will switch off, cut off you from the internet, cut off you from SWIFT. What do we need to do? We need to ensure our security as a state. Then we have this law on personal data. Those who criticize this law, they said that they were saying that there was no constructive dialogue with the Committee on Information Policy. Everything was done in a clandestine way. We do not listen to technical data and do not consult with experts, but this is all nonsense. I started thinking about personal data at 4 o'clock when I got up and went to the airport and flew here. All this way I was thinking about personal data. I would like other people to do likewise at 4 o'clock, yes, in the morning. Well, but everyone has its own biological clock. Well, we're talking about unreliability or insecurity of data. What is the line which should be crossed by companies that aggregate various kinds of data? We haven't heard about that so far. In our committee, we don't have a crowd of internet community or aggregators of data who store personal data, who would propose their own security systems to us. Well, there is total silence. We are prepared to criticize any law, and I'm quite open. I'm looking at you, the representative of the sector, and as usual the sector is hiding somewhere, never comes up with any worthwhile proposals, and we as MPs have to do everything ourselves. We are forced to do it. Therefore, I would like to urge you to enter into constructive dialogue. Please contact the members of the Committee on Information Technology and Policy. There is no problem with that. There is international experience. We have been discussing it. Not long ago, on the 13th of March, a law was adopted in the first reading on the protection of personal information. So information must be deleted from search engines, personal data, undesirable information as it's called. We are obliged to do that on the territory of the Russian Federation. We, our colleagues from many political factions in the parliament, we've just introduced this draft law into State Duma, into the parliament, so that search engines delete, remove uncorroborated information about our citizens. So this draft law, which is similar to laws adopted in Europe, is now in Parliament, because our citizens must be protected. Their information must be kept on the territory of the Russian Federation. This draft law, when it was in the making, we came across a lot of technical problems. One large corporation came to us and they said that they have their own security system in which they invested a lot of money, and the information isn't compatible with the system of data centers on the territory of the Russian Federation. We are happy to discuss such technical issues with them. This is something to be discussed. But when they're telling us, please do not enact this law for another year, 2 or 3 years. This draft law was prepared in order to ensure security of personal data of the citizens of the Russian Federation. The more we procrastinate and delay this legislation, the more vulnerable our citizens' personal data become. Because at the time when people from the West are saying that they're going to cut off us from the internet, I hope that no one will do that and nobody will go on the ocean floor and cut the cable, and we will continue to receive access to the internet. We hope that our international colleagues will stop finally making such blatant statements. We understand that the technological situation must be under full control of the technical supervisory authority of the Russian Federation, because they are responsible for the application of this law. And let's hope that the situation that will evolve by the autumn of this year, and we are going to talk with Roskomnadzor, with the supervisory authority, in order to overcome all the difficulties. There may be a need to introduce some amendments in order for this law to be enacted, and so that it could smoothly come into force. But I think we will overcome these problems. In principle, taking into account the way how we had constructive consultations with some representatives of the markets, and some companies said that they would be prepared to organize the storage of personal data on the territory of the Russian Federation in 3 months. There are companies from China and from Europe who made such statements and proposals. So, to say that companies cannot form an appropriate approach to this matter in a year or 2 or 3 or 4, this is something that is a surprise for us. Traditionally, personal data were never stored in the Russian Federation. They were kept in Europe and the US, and when we started thinking about this in Russia, we started to be criticized. People asked us, why should you want to store them in Russia? But in our committee, the dialogue between MPs and the market helped us to arrive at a consensus, and we decided that we need to store data in Russia, and the technical issues will be resolved as we continue these debates. I'll be happy to take any questions, relevant questions, but once again, I would like to reiterate that for us, the government, the security is priority number one, and business is priority number two. While your personal data have not been stolen, while they haven't been taken away from you, and while someone haven't used your credit cards, you don't think about that. You are prepared to discuss everything, but as soon as such data has been sold from you, and then all of you, well, start to agree with government intervention in the safekeeping of personal data and oversee this process duly. Thank you for your attention. Vadim, thank you very much. Now, well, I think that the representatives of the business sector, well, have listened and heard your constructive criticism. I don't know whether people from the villages that you referred to came to your committee before this draft law was adopted in the first reading, but we somehow stop this gap and we will come and you will see us in your committee. Now, well, we will questions a bit later. We have a lot of speakers. I will give you the floor at the end for a question. We would like to listen to some more presentations, in particular from a representative from the Ministry of Communications of the Russian Federation. Roman Kuznetsov, who is director of the legal department of the ministry. Well, could you please share with us your vision of regulatory mechanisms and handling of personal data, and maybe you will also express your opinion about the well-known amendments to the draft law. Well, I will be brief, dear colleagues. Colleagues before me said that the volume of information to be processed is growing, and of course refers to personal data, and with time the greater volume of personal data that are processed creates certain threats and the difficulties. In spite of the fact that this law, but it was a draft law, the ministry wasn't involved in the preparation of the draft law, but we think that this law that will be enacted soon is quite specific, quite understandable, and it well regulates this sphere. With regard to interpretations, we met many times both in the ministry and the supervisory authority, and we discussed all the situations, and we have found ways to overcome all the problems that arisen. We think that the law is good. It should be complied with the way it is written. You should not try to interpret it, you should just apply it. And what refers to amendments, this issue, as we think, can be discussed only that we accumulate some law enforcement experience, and not at the stage of theoretical discussions of what may happen, because all those fears have not yet been confirmed by any hard facts. I will be happy to take your questions. Yes, this was very brief. And now we have an opportunity to ask some questions, to address them to speakers. Could you please take up a microphone before you say something? We are a large production company, an international corporation. We are preparing to the implementation of this law. It is timely, it is a good law, it is an adequate response. But at the same time, we understand that for its implementation, we need time and money. I don't know how Chinese companies can do that in 3 months. Our company has to work for 1 year while we are transferring our services servers from Europe to Russia. And then there was news in the press that for businesses there will be another delay for the implementation of this law. What can you say about this possible delay? So the Chinese guys probably came to 3 months thinking that all the population of the country will be working on this. If someone can do that in 3 months, then I think other companies can become more active and implement all this in the same time frame. Well, let us think about what hindered you to move the data to of the Russian Federation in the previous year while this law was being discussed. In January 2015, the law is going to be enacted. I introduced this amendment in the second reading, but then we had a discussion with the industry and then moved it to the fall of 2015. A lot of time has elapsed. We discussed that in mass media, and we announced this information in the mass media a long time. As soon as this information appears in the media, this is a signal for you that you should start to prepare to the implementation of this law. Once again, we cannot adapt ourselves to each and every company. We respect you, but in the industry there are a huge number of companies who aggregate personal data on their servers. We have appropriate analysis, and we are positive that by September companies will be able to store personal data in Russia. We have lots of data centers already. You can lease appropriate equipment from them. It is not very costly, and gradually you will be able to adapt your own capabilities so that you could store this information in your own data centers. Well, there may be customs benefits for companies who produce data centers. As an example, I'm not lobbying anyway. There is a company that produces data centers, and I, as an MP, can put forward an initiative to grant them customs benefits and holidays, but we are interested in supporting Russian companies who produce data centers. We are developing Russian industries, but if a company doesn't produce data centers itself, I can come up with this initiative about customs benefits. But so far I haven't received any proposals to that effect. I hope that by autumn you will be able to transfer the data of our citizens onto the territory of the Russian Federation.
Let me remind you that the law was adopted in July of last year. Yes, in July of last year. So until September 1st, there would be actually more time passing than 1 year. So you should have been able to do your job. But when the proposal was actually to make the deadline of January 2015, the operators were very much concerned. They were started applying to all kinds of authorities. But then, as soon as they realized that there would be some delay, they all come down and kind of like were sitting on their hands. Now it is 3 or 4 months before the next deadline, and they again start to be agitated. So it seems like people were doing nothing. So they waited until the problem goes away, and they would be doing something else, but without thinking twice about this. As far as data processing centers are concerned, DPCs, we also met with DPC owners in the Russian Federation, and they said that they were ready to assume the business of new entrants. I know that this is an issue that is being discussed quite extensively in the professional quarters, the so-called mirrored storage of data. So what can you comment on this? Well, there's no definition of a copy, of a mirror, of anything in the law. So any personal data would be personal data. And when the law says that such processing activities need to be returned to the Russian Federation, but there's no word of only in the territory of the Russian Federation. So to the same extent, or less than that, it can be also processed outside the Russian Federation. So there is no real restriction on that. So a mirror is possible, but the main processing center should be in the Russian Federation, but a similar amount of data or less than that can be processed outside. Thank you for this clarification. And now I would like to give the floor to the Ombudsman. On the matters of removing the violations of entrepreneurs' rights in the area of regulation, control and development of the Internet to Dmitry Marinichev. So I wonder what you think about of this, about all this. Good afternoon now. Indeed, it gives me pleasure to listen to all the polemics and discussions here, but frankly, when I was asked to present at this panel, I was a little bit concerned because I'm no lawyer, and for the first time I ever heard about personal data protection only a year ago, because before that I never actually thought about this. But I'd say that I was not happy to listen to all of this, and perhaps I'm the only one who represents here business in the development of data protection systems, not only in Russia but elsewhere. And I have nothing to do with the legal trade. I'm an engineer first and then a businessman. So whatever we are discussing here is probably not possible, because we cannot stand in the way of technological advancement. When actually cars first appeared, there were laws that they should have had a forerunner in front of the moving car, so to warn the pedestrians about the incoming danger. Now, we are probably in the same situation here. It's like, of course, you can limit the speed, 110, 130 kilometers an hour. Any country is free to do that, but you establish a speed limit based on your progress. Germany says we have very good cars and very good roads, and we don't limit the speed. France cannot afford the same. Maybe France will one day have good roads and good cars, and they would remove the speed limit. You have all kinds of other limitations and restrictions, like pedestrian crossings and something else, other technological barriers that make the life of people easier. You have safety bags, you have safety belts and everything, but it means that you need to protect the person. But what would be the definition of personal data? Where to store data, in Russia or not in Russia? Well, I would be interested to having companies coming to me and, you know, leasing one rack, one data rack or two data racks, and keep and store data in my DPC. But it could be otherwise. Paris was once a city where the width of a street was no more than 1 meter. Then Paris was rebuilt. Now it looks like a miracle. But they had a regulation in place, and there was an urban development plan for Paris, quite understandably. I mean, You can see the arches of the Champs-Élysées, you can see all kinds of architectural monuments, but this is done according to a plan. The same is happening in the digital domain. Keeping data in one place is nonsense. The speed of transferring data worldwide is a millisecond, and the price is 0 cents. You can have copies of data, and the amount of data that we collect on people is truly big data. So I'm actually categorically against any such identifiers. I think in 10 or 20 years we no longer would have any IDs or passports. Raise your hand, who has a smartphone? You see, 99% of people have a smartphone. Maybe some probably still have this banana-type Motorola old devices. But again, this is a new thing, and basically, not claiming, I'm saying that we may not have any IDs in the future, but only smartphones. You say, let's not keep data outside Russia, but your software in your mobile phone basically collects data about you and stores data in the memory of your mobile phone. But then you can pass this information on across borders, but you can do that. But who says that you only can have servers in the Russian Federation with the only copy of data in the territory of Russia? Against whom are those laws being written, in Europe or in Russia? Against people, because governments are afraid to lose control over people for the benefit of their authority. And it's like the Roman Empire collapsing into individual parts, and you have feudal communities building their own fortresses. And this is the way this is the approach we are taking to digital data. We're trying to build our isolated DPCs and domains, but nothing good would come out of this, because data is like oil moving on an oil pipeline. It moves across the world, and when you buy a router, and or you probably install a time capsules from Apple in your apartment, you already have internet, which goes hierarchically up and goes into the global network. So all of us, and each of us, would be a piece of the internet walking around. We are the internet, so you cannot really personalized data there. To your smartphone, you can authorize to keep your personal data in Facebook or elsewhere. You not even think that your smartphone has over 30 gauges, I don't know, angle velocities, because we can identify the way you are walking, and we can identify a person by the habit. So this is now a challenge. How would you oppose this technological progress that works for the people? Government is something, the state is something that whereby you agree to cede some of your rights to get protection from community. This is the law of survival. So we have our personal liberties, we have our personal 10 commandments, but federal law 283 has nothing to do with that. And same, by giving away your personal data to a server, yes, you have an infringement on your rights, but you are also getting some important and significant services. Take medicine, take TV, anything. To give you a simple example, we have a service called Yandex Taxi. You can have your smartphone and see where you are, and then you are met by a taxi, and you already have some personal data from a taxi driver who sends you his telephone number and his name. So this is sharing personal data. Now, would those taxi drivers actually start hiding their personal data? I mean, those taxi drivers who don't want to make money, they would probably do that, but otherwise not. So, I mean, sharing your personal data is getting also some public services. So I think legislatively regulating the personal data protection in the way we are discussing now is like trying to preserve the digital Middle Ages, I would say. I think this is nonsense. So I'm an engineer, and that's my vision for the next 20 years. Whoever wants to decelerate progress, there's nothing good coming out of this. As soon as the plane takes off, I mean, whatever you do, you cannot stop the plane or the progress with the plane development. Today, the misunderstanding of the fundamental technological values, the fundamental values of the Internet and the services offered by the Internet causes something that identifies our approach to society. But the people, electors, wherever they are, in the city or in the village, they don't care about personal data protection. Because in a village, all know about each, and they basically can spot people from 200 meters away, and they would identify this person is going to, I don't know, a store or to a neighbor. So they can immediately tell it by gait of your neighbor. And today, we also have a lot of gadgets that can not only collect data but also to transmit videos into the cloud. So I watch at you and I have your videos, your faces on my time capsule or in my cloud. So do I need to have your consent to store such videos for my personal use or not? Because I can identify all of you, because by 99% probability you probably have your profiles in social networks. So you wrote to somebody on a website, so I would know who you are and what you've been doing. So, but this is exactly why you have the contacts in your mobile phones. But, I mean, 50 years ago, you could have gone to a phone booth and checked through the personal phone records and call anybody else. So why not allow this again? If I don't want my personal data to be available worldwide, this means I don't want to use the benefits of the advanced society that I live in. So I can go somewhere into a far and remote place, I don't know, in Siberia, would be fishing and, catching animals and whatever, but living outside the digital era. But if we're opting for the technological way, for the technology that we're comfortable with, we have to agree to the dissemination of data. So we only can regulate the regulation of personal data, or any attempts at this simply means that we misunderstand how data are stored or transmitted. If you start to regulate what is within data, then this is the function of the government, and it is up to the government to do so. And the way to regulate this at the country level, it sometimes doesn't make sense. You can keep your records, and we basically delegate our authority to the state. So you never where such data is going to be retrieved or stored. So again, to discuss anything, we need to understand this, and to understand this, we need to appreciate this. So, as an internet ombudsman, as an engineer, a person who knows how to build information networks and DPCs and telecommunications grids, I can tell you how technologies would be perceived in a natural way in 10 years, and I would know what needs to be regulated in 10 years. I don't know why would you be willing to try to regulate, I don't know, archaic ideas, like trying to prohibit skyscrapers higher than 5 floors, thinking that such a skyscraper would fall down. I don't think it will do so, because we have technologies in place. So we should not be really apprehensive of the new things and new developments. That's my thought. Perhaps you should have a fun community somewhere in the social media. Maybe I would join that as well. But let us proceed to a more specific subject, and I would like to give the floor to Uliana Zinina, who is an advisor on legislative and regulatory matters of Microsoft Russia. Thank you, Alevtina. If I may ask for a presentation, thank you. Indeed, it is a responsibility of sorts to be the last to speak, but to wake you up, I have some nice pictures to show to you, but with some very boring legal texts there. So for the last 2 hours we have been discussing some high things, theories, philosophies, etc., which probably is useful, but as a matter of fact I have a very boring legal presentation for you to enjoy, and I actually can advance my slides. Now, Dmitry, I think, was quite emotional when he was speaking about the way technologies are taking, and the fact that we are all living in a new world, and our world will evolve, and technologies are evolving at a faster rate than we could have imagined only a few years back. And I think that the few of us have a good understanding where such technologies would lead us. And of course this causes new challenges and even threats to lawyers, to legislators of our countries. We live in an era of cloud computations, and probably you never imagine or think about this on a day-to-day basis, but this is so. We are all using social media and emails. We are all using cloud storages where we can keep and store huge amounts of data that we possess. It could be movies or music or documents. And we are all using also online booking systems, again, cloud-based technology. Anything that surrounds us is basically a big digital tomorrow, which is already with us. And Mikhail mentioned that as well today, but the notion of personal data in clouds is getting bigger and bigger, and our data about our activities would multiply. And there's a long-standing issue that people are trying to find a solution to in Europe, but also in Russia, and the issue is whether new identifiers actually identifiers that can be equal to personal data. Is an IP address personal data, or would a unique identification number for users also personal data or not? Depending on the answer to this question, you also apply some regulation there. We also observe that, well, actually we're living with it, we also observe that with clouds we also have some jurisdictional problems and the issue of the application of law. Would those standards of the international private law be sufficient or not? This is something that we lawyers actually face every day in using clouds for proper qualification of legal relations. What the governments face in their attempt to regulate certain processes. And correspondingly, we have another issue that we have discussed already today. I'm talking about limitation on the transborder transfer of data. Clouds are global technologies, and a global cloud is always transborder.
If we use an email of a certain provider, Microsoft, we have this email, we provide this service. Of course, you come across the need to transfer data in a transboundary format, or you use booking.com. It also involves transferring data across the borders, and here the issue of regulation arises with the development of global cloud systems, with the development of technologies, with the development of national cloud providers, national data centers possibly. Of course, problems arise with compatibility of security requirements that are applied by this or that provider, for example, in accordance with his own national legislation. Now we can see that there is no general understanding, no set of general standards that would be applied by providers in different countries. For example, in Europe, a standard, the security standard, ISO standard, has been adopted, specifically aimed to protect information in cloud systems. But still, the standard may not be compatible with the requirements related to security in this country. Traditionally, security requirements are adopted by the FSB, Federal Security Service Bureau, and those regulations are quite strict. These bodies, well, they are strict in those requirements that they put forward. We have already talked about that, and we will continue talking in the future, even to a great extent, about the development of big data, open data, and those data arrays that many companies put together. They are used quite often not only for certain commercial activities of this company, they are used to provide socially important services and goods. We can take a specific example of Yandex company. They use data, they provide certain services to the population, to the government of Moscow administration. The last, but probably not the least important problem that legal experts come in terms of regulation of cloud computations. It's broadening the sphere of reference of government bodies in terms of collecting personal data. There are not only jurisdictional problems. Governments more and more often now are trying to get data which are kept in a different country, and this is one of the jurisdiction-related problems. Where are the borders, sovereign borders of various countries? Law enforcement authorities of these countries, in terms of the collection of data, what shall they base this activity on? National, international regulations? I'll try to be brief. Yes, I think that I tried to show on this graph how a cloud is regulated in Europe. In Europe and in the countries of many other regions, there is no centralized regulation. There is no specific law that would be called like a law on cloud computation. Clouds require universal and comprehensive legal approach, and of course the legislation on personal data is the most well-developed part of this regulations. In Europe, they've been thinking about that for a long time, and they have a lot of legal legally binding documents that are used in Europe in order to regulate these relationships. Those are conventions, the directives, soft law norms, contractual arrangements and strategies adopted by countries in order to stimulate and promote the development of cloud technologies. If we go further, we will see that in Russia, clouds and the regulation of cloud computations has not yet been well developed, and the legislator is not paying much attention to it at the moment. We have only a few components in place that are shown on screen. And we can also see that cloud computation, in spite of the lack of a universal regulation, in Russia we apply a whole number of legislatory acts. It's the General Law on Information, Civil Code, which contains overall requirements to contractual relations. There is a law on personal data and many others. But since we're talking here at this round table about personal data specifically, I will now try to briefly tell you how our law on personal data is used to cloud, with regard to cloud systems. You can see here how this legislation was evolving and what kind of legislation is applied depending on the type of information that is processed in the cloud. So when a certain kind of data are processed in the cloud, certain limitations or restrictions are applied. If it is restricted information, confidential information, there may be information that is not restricted or confidential. The main provisions in the law applicable to cloud services. So third-party processing. So the law regulates the relations between the operator and the processor, if it is a third party. We have been speaking very emotionally about the requirements on collection and storage of data on the territory of Russia, transboundary data transfer. I told you that clouds are global, and the requirements related to the security of data processing. So processing by third parties based on a contract is one of the key elements that is used, that is, well, governs cloud computation. Because it is important, because this division of subjects of this work helps to identify the limits of responsibility of each party. There is an operator who collects data, personal data, in accordance with his purposes, and there is a processor of personal data, which uses it's a cloud provider, in fact, who does not define the purpose. He doesn't own these data, he just does something to process data on the basis of a contract that he enters into with the operator. Next come the requirements related to localization. Yes, we said today that primary collection and storage should be made with the help of databases on the territory of the Russian Federation, but transboundary transfer is not prohibited, as my colleague said earlier. Therefore, personal data, while major requirements have been complied with on the storage of information in the territory of Russia, then they can go to any cloud in any country, well, taking in mind all those restrictions that are shown on the slide that were mentioned, the European approach, criteria of adequacy of various countries. In our law we also have such criteria. There are so-called adequate countries, quote unquote, those countries that have signed the Convention of the Council of Europe, and those countries that our supervisory authority recognizes as such by its order, and there are inadequate countries, quote unquote. It is possible to transfer personal data to those countries as well if it is necessary to fulfill contractual requirements. It may be an international contract that is involved there, or some other conditions that apply. The next element okay, now we have the right slide on the screen. Another component that is related to cloud technologies is security of data processing inside the cloud. We can see that in accordance with the law, there is a division of responsibility between the operator and the processor of data. There are different levels of protection that are provided, and the operator of personal data must comply with those requirements. And depending on the level of protection, appropriate measures of protection are selected and used. Here I tried to remember and remind you about those initiatives that were related to attempts to regulate cloud systems, since computation in the cloud are very important for the national economy. They are developing at a very high pace, and the legislation sooner or later will have to take these technologies into account and have certain instruments to regulate them. Over the recent time, we have seen an attempt to create such a law by the Ministry of Telecommunications. There was a separate law prepared. Before that, a working group was set up at the Russian Association of Electronic Communications, and some of the best countries' lawyers working in the sector, some of them are present here today. They tried to from taking into account the theory of law and the level of legislative development that we currently have, to propose certain legislative initiatives or amendments to existing laws that are required in order to promote the development of cloud technologies. Why is this important for my company? As was correctly pointed out, security is one of the main elements or priorities here, and the security of Microsoft products is the main and key task for our company. If our clients do not have trust in our technologies, no one will use them, and the protection of our users is a key priority for us. Therefore, we use the principle called privacy by design. So the requirements for the protection of data are the most important thing, and they are designed, they are included in the design of the product at the very first stage of its development. We were one of the first companies which implemented the ISO standard, which was adopted not long ago, about data processing in a cloud. We are one of the first companies which received a go-ahead from the Article 29 of the working group in the European Union, saying that our products are in full compliance with the European requirements, and all this demonstrates how much we care about the data. This is my last slide. Fortunately for everyone here, my major conclusion is, as a lawyer I make it, There is no universal approach to the regulation of cloud technologies. For each country, for each specific situation, there may be different solutions. But since the cloud is global, it is not possible, I think, to restrict the territory, to introduce additional limitations for all data. Security of data processing, security of information, protection of citizens is an important task of the government. No one will argue about that, I think. But we need to approach this topic cautiously, and we should not ban or prohibit the storage of all data outside the territory of the country. The government should take care of the protection of national secrets, and they should be kept here. That is all from me. Thank you very much, and sorry for taking so long of your time. Thank you, Liana, for, well, bringing us back to some legal and methodological issues. I can see that Vadim made several comments, and probably I will invite you to the panel next year, and we will have things to discuss referring to regulation. Okay, now on a serious note. First of all, I'm very thankful to our colleagues from Megaphone, from Counsels, who supported us in a difficult minute and helped us to organize this round table. I'm very thankful to all the panelists, representatives of Germany and the UK. Thank you for coming over and telling us about your experience. I'm thankful to the representatives of the Parliament and the Ministry of Telecommunications, and this, a special thanks goes to our Ombudsman. I felt secure in such strong masculine hands, so yeah, I relaxed kind of. But, well, jokes apart, we have agreed that there is understanding that a dialogue with our Parliament is possible, and in the framework of the Association of Corporate Lawyers, and as a result of very difficult negotiations that we carried out in the course of this round table, we agreed that we will go onto the territory of the committee ourselves, and then we will bring with us our message, and I think we'll be heard, which is logical that for the government to listen to us. But we will be disciplined, and we will explain everything in detail and clearly. We cannot say that we have come to any decisions, but we have made a step forward. We have heard some clarifying notes and comments, and we heard certain words about how we should regulate the sphere and how it is done in other countries. Like, let's do more work in this area in the future.